Hi, Caroline.
Hello.
I'm Sarah Posner. This is The Posner Show, and today my guest again is Caroline Mala Corbin. We are going to talk today in a follow-up episode to our conversation last week about the Supreme Court's decision in the Hobby Lobby case. We're going to talk today about its rather unusual order that it issued late Thursday before the 4th of July weekend in the Wheaton College versus Burwell case, which is one of dozens of nonprofit organization cases that have challenged the contraception coverage requirement under the Affordable Care Act. And let me just say by way of background that the objection in the Wheaton College case and in the similar cases is a little bit different than the objection in the Hobby Lobby case. In Hobby Lobby and other corporations did not have any kind of exemption or accommodation under the regulation. Wheaton is one of the organizations that has what's called an accommodation. Churches and other houses of worship were exempt entirely. Religious universities, hospitals, and so forth had an accommodation which requires them to sign basically a form that tells the government, we object to providing this coverage. Please alert our insurance carrier to provide the coverage without us being involved at all. And that's what they object to. They object to that form. Also, they claim being a violation of their religious exercise. So that's the case that reached the court in a rather unusual procedural posture. And that was one of the things I think that a lot of people were surprised about the court's ruling, because it reached the court at the injunctive phase of the case and before there was a true split in the circuits, in the federal circuit courts, on the merits of these claims. So can you talk a little bit about that?
Sure. So what's unusual, as Justice Sotomayor was explaining, that the grant of injunction is very unusual in this case because they usually only grant an injunction when the outcome is quite clear. And in fact, there is a circuit split, and by definition, the outcome is not clear if there is a circuit split. So this is a sort of extraordinary remedy, and it's very unusual to grant it, especially in the circumstance of having a circuit split.
So basically, the courts below have not decided this case on the merits yet?
Courts below have, and they've come out differently.
The court in the Wheaton College case?
Oh, I'm sorry, the court in the Wheaton College case, but there's many of these cases working their way through the courts, and circuits have split on whether they have a valid claim that signing this form raises a valid RFRA claim.
Okay. And so it was like the court had issued, in a way, a decision that they issued an order that seemed to address the merits of the case, even though usually in these sorts of, when this sort of injunctive case reaches the court, they basically say, yes, you have an emergency injunction pending appeal, and they don't really get into the substance of the case, but the majority did really talk about the substance of the case in the order.
Although it did say at the end that do not consider this a holding on the merits. So
right.
They discussed it, but it is still not considered an official holding. But again, the most unusual part of this injunction is that it was issued at all.
Okay. So then the other unusual thing about this order was that what the court had suggested on Monday in the Hobby Lobby case, that the government had already demonstrated that it could guarantee copay-free contraception coverage to women without burdening the religious exercise of entities, that the government had already demonstrated that it could do that through this accommodation regime. And so the court had suggested on Monday, why couldn't the government apply that sort of regime and accommodation to for-profit corporations? And so then the challenge to that procedure comes up to the court in the Wheaton College case, and then suddenly they seem to suggest that, well, what we said on Monday was a good way of accommodating the religious objections today we think could be a substantial burden on their religious exercise, which to me was kind of the most shocking thing, because it seemed pretty clear on Monday that they thought that this might be a good idea. By Thursday, that had devolved into a substantial burden on religious exercise.
Yeah. So part of the Hobby Lobby decision turned on the court's finding that there was an alternative method of providing contraception, namely the method that is now at issue in this course.
Mm-hmm.
And as you said, the court suggested that this is a valid alternative way of providing contraception that would not impose on people's religious beliefs. And then in this decision, they seem to question whether it is in fact an available alternative.
So what does this mean for the dozens of other nonprofit cases going forward? A lot of them are at different phases of litigation. Some of them are already on appeal in courts of appeals. Some of them are still at the district court level. How do you think that the lower courts are going to interpret this order, which the majority says is not a resolution of the case on the merits? So is it binding precedent on the courts? What are they going to do with this?
Well, I think they will read it as the Supreme Court signaling that they might have a valid claim, and that in the interim there should be an injunction granted as to the application of the contraception mandate.
And so then what happens?
To sign the form.
Right. And so that would mean that the courts would grant all of these nonprofit organizations an injunction from having to sign the form until there is a decision on the merits, during which they would have to prove that signing the form is a substantial burden on their religious exercise. Or maybe in the court's view, not really a substantial burden, just a burden.
As I had mentioned in our previous discussion, one of the most troubling aspects of these set of decisions is that the court seems to be rewriting the Religious Freedom Restoration Act to require only a burden on religion rather than a substantial burden on religion before anyone is entitled to a religious exemption.
So do you think that as a result of the Hobby Lobby case, which is binding precedent on the lower courts, and this signal from the court on Thursday in the Wheaton College case, that the way the lower courts will look at these nonprofit cases, these cases where the plaintiffs are objecting to filling out this form, they will essentially be looking at does the organization claim it's a substantial burden on the religious exercise that is good enough for us?
That basically seems to be the court's position at this point, is that if plaintiffs sincerely believe that as a matter of faith it imposes a substantial burden on their religion, then as a matter of law, it imposes a substantial burden. Of course, that's not how we should be reading the act. Right? As Justice Sotomayor says, just because you believe it's substantial doesn't necessarily make it so.
Right?
There should be some objective limits to what's considered a substantial burden on religious practice.
And filling out this form, it's hard to see how filling out a form that basically shifts the burden of doing what you consider to be the immoral thing to somebody else is a substantial burden. They make this argument that they're facilitating the provision of the coverage despite their objection, and that is the impact of signing the form.
Exactly. It's a facilitation. So first I hope everyone is quite clear that these organizations are exempt from providing contraception. They are not required to provide it. So what they are doing is they're signing the form that states that they are a religious nonprofit who object to contraception. And that is what they are claiming is a violation of their religious beliefs, because they argue that it's facilitating abortion, because once it's filed, then their employees will get contraception coverage, no thanks to them, but it would allow the next steps that are necessary in order to provide it. But of course, there are a lot of things wrong with this facilitation argument.
Right.
One is a facilitation argument in general has no stopping point. You can argue just about anything facilitates abortion. If you're opposed to abortion, you could argue providing a salary to people who can then go use it and pay for abortion is facilitating. Or you could argue, well, hiring women in the first place is going to facilitate it because now they have access to contraception. And of course, again, as Justice Sotomayor made clear in her excellent dissent, is that it's not filling out a form that triggers the provision of contraception. It's federal law.
Right.
They're not facilitating it. The federal government is facilitating it by mandating it.
Right.
And that, of course, is separate and apart from the whole problem of their scientific inaccuracies around the claims.
Right. We discussed that last time.
Their argument is, and they're focusing only on the morning after pills, and they argue providing morning after pills is facilitating abortion, when, of course, morning after pills have absolutely nothing to do with abortion.
Right. They make abortion less likely to happen.
All the scientific studies make clear that they work by preventing ovulation. So there's no killing of embryos because there are no embryos because there are no eggs.
Right.
That is the scientific fact.
Right.
And it's really disturbing to think, right, that their scientific misunderstandings have the force of law. Right? And so part of the problem of not having objective criteria to measure people's substantial beliefs is this kind of scientific misunderstanding suddenly becomes embedded in our law.
Let's talk about the facilitation argument a little bit more, too, because we didn't get into that last week when we were talking about the Hobby Lobby decision, because that really wasn't a component of it. But because these nonprofit cases raise the question of filling out the form and the facilitation. So the Seventh Circuit, which decided in the government's favor was it in the Wheaton College case or was it in the Notre Dame case?
Notre Dame.
Yeah, right. Okay. And they made that analogy to a Quaker who is a pacifist and doesn't want to, wants to raise a conscientious objection to being drafted. And they say, well, that doesn't, just because that would trigger the government drafting somebody else instead, it's like making that argument that, well, I don't want to even raise my objection to the government because by raising it, that would cause the government to draft somebody else in my stead, and I don't want to facilitate that. They drew that sort of analogy, and I thought that was an interesting and apt analogy to this, because you're basically saying, I don't want to sign this thing stating my objection because my objection necessarily triggers somebody else doing the thing that I didn't want to do.
Right. And again, in the end, it's not the signing the form that results in contraceptive coverage. It's the federal law. So the facilitation argument just does not fly. And that was partly the point that Judge Posner was trying to make with that analogy, is that
no relation,
the reason the person is drafted is not because somebody else is objecting to being drafted. It's because there is a draft. Right.
And here there is a regulation that requires employer-provided health plans to cover the contraception. Okay, so in the Hobby Lobby case, the elimination of the substantial part of the substantial burden test really gave a pass to their claim about how the emergency contraception and IUD operate, right? And in this case, it does that too, because Wheaton is an evangelical institution that, similar to Hobby Lobby, is objecting to those 4 methods of contraception.
I wasn't sure if it was 4 of them or just the morning after pills. I think it might only be the 2.
Oh, they don't object to the IUD?
It was not clear. I didn't find anything that stated it clearly one way or the other. But not all contraception.
Right. So the substantial burden, that question comes into play both with the question of how the contraceptive drugs and devices work, but also it comes into play with regard to this form. Because the form, not only does the facilitation argument fall flat because of the reasons why we just discussed, but it seems like, well, if there is no facilitation, if you don't have a good facilitation argument, then how can you have a substantial burden argument?
But as I said, there are 2 major weaknesses with their facilitation argument. One is their concern is about facilitating abortion, and these contraception devices have nothing to do with abortion.
Right.
And frankly, the case should have just ended there.
Mm-hmm.
But even assuming that they're wrong, correct, which they're not, right? Facilitation arguments in themselves are problematic because they have no logical stopping point. As I said, just about anything, there's so many things that they can do that would be considered facilitation that it opens up just about anything. Anything could be objected to as facilitating something they don't agree with, right? Hiring women who've had an abortion facilitates abortion. Hiring someone who's ever spoken in favor of abortion. Hiring someone who's friends with someone who's had an abortion.
Hiring somebody who donates part of their salary to Planned Parenthood.
Again, all of these things in theory could be considered facilitation of abortion. And it may be that people, in fact, sincerely believe that all these things are facilitating abortion. But as a matter of law, we have to draw the line somewhere and say, you know what other people are doing can't necessarily be considered a substantial burden on your religious practice.
How surprised were you that the court seemed to shift from Monday to Thursday, where on Monday they basically said that this seems like a reasonable way of accommodating the objection, filling out the form. And then on Thursday, they seemed to take a different tact, which was part of the reason why the dissent was so blistering in this case. They basically were saying, we can't rely on court precedent, much less over the years. We can't even rely on it over the course of a week. How surprising and unusual is this? And what do you think it does to the lower court's ability to read the tea leaves in these cases and the public's confidence in the court relying on its own precedent?
I definitely think that, as Justice Sotomayor pointed out, it really undermines people's confidence in the Supreme Court if people cannot believe they mean what they've just said. I mean, that, I think, is a fairly straightforward point. Personally, I was not shocked because they were very careful to mention in their opinion that they were not, in fact, holding on the question of the nonprofit accommodation. And I thought that was a bit of a giveaway about what they might be thinking, especially given that they seem so intent on rewriting RFRA. Right.
But then we have Justice Kennedy's concurrence, which gives us another tea leaf to look at, perhaps?
So one of the big questions is, what does this mean?
I mean his concurrence in the Hobby Lobby case, but go ahead.
Right. Yeah. So one of the questions is, what does this mean, I think, as you mentioned, outside the context of contraception? And there were certainly indications in the opinion that they wanted to confine the ruling to contraception and not have it expand to, for example, gay and lesbian rights. Although, as I said before, the reasoning can easily be applied to someone who objects to gay and lesbians and either hiring gay and lesbians or providing accommodations for gay and lesbians. And the question is, how would the court deal with that case? And the court suggested occasionally that discrimination would be treated differently. Right? On the other hand, this case itself involved discrimination. So
right.
I think it's still an open question.
And so, but was there any hint in Justice Kennedy's concurrence in Hobby Lobby about how he would rule in these nonprofit cases, in the form filing cases?
I don't remember reading anything one way or the other in his concurrence.
So how do you think the lower courts are going to look at the nonprofit cases now? Reading this order from Thursday together with the Hobby Lobby case, does it not seem like they're going to have to rule that that the form, filling out the form, violates their religious exercise, infringes on their religious exercise?
I'm not sure how much discretion the courts will feel they have because, again, the court did not say it was ruling on the merits. On the other hand, it certainly seemed to signal what they thought. So it may be that the courts will try and do what they think is correct and then see what happens. that's a prediction I'm not able to make.
Right. So suppose there's a court of appeals that rules in favor of the government in one of these nonprofit cases, and we have a genuine split in the circuits, and it goes up. One of these cases goes up to the Supreme Court. The court would be faced. I mean, the court could still, relying on its own precedent, affirm a court of appeals ruling in favor of the government. I mean, the precedent is there, technically speaking.
The court could rule either way.
Yeah.
It's the Supreme Court.
Right, I know, but there is in its own
precedent.
As
I say, there's nothing in Hobby Lobby that directly addressed the question and held, right? It would be dicta regardless.
Right.
But it was very careful to say, we're not ruling on the merits, even though they seem to be relying on the question, which is, again, what is so disturbing to so many, right? It seemed to be saying this is viable. It seemed to depend on the viability for its ruling in Hobby Lobby. Mm-hmm. And then it turns around and said, actually, maybe it's problematic as well.
Right. So is it unusual for the court to basically, one of the objections that Justice Sotomayor had in her dissent was that the court seemed to be wanting to rewrite the government's regulations. Is that, I mean, do you think that was a reasonable objection to make to what the court was doing? And is it unusual for the court to basically say, well, if they had drafted the regulation in this other way, we wouldn't be here?
Honestly, I'm not familiar enough with similar admin kinds of questions to say whether it's unusual or not. It would not surprise me if it was unusual, because they basically said, all right, the government had set up the requirement, right? If you want to opt out of the exemption, you have to file this form. Mm-hmm. And the Supreme Court held, no, actually, you don't have to file this form. You could just send a note to the government.
Right.
Which, again, I don't know what kind of precedent there is for that kind of decision.
So, but I mean, legally speaking, what's the difference between filling out the form and sending a note to the government?
It's an interesting point, because if you're looking at it from the point of view of the nonprofit and the facilitation argument, it's not clear why the one form would be considered facilitation and not the other form.
Right.
So I'm not sure what they gained, except to make it that much more administratively difficult for women to gain access to contraception, which perhaps may have been one of their purposes.
And also maybe a little bit more of a burden on the government to sort everything out, as opposed to having everybody fill out the same form.
Right.
You know, what is the format for notifying the government if you're not going to use the form? Is an email okay? Do you have to send a registered letter? You know,
it definitely makes it more complicated.
Yeah. So, are you thinking, do you have any insight into how far the court is going to take this rewriting of RFRA? I mean, do you think that this is going to have reverberation? We talked about gay rights issues, perhaps not based on Justice Kennedy's concurrence and other things that were said in the opinion, but does it have other reaching applications, particularly in light of what the court has signaled with this possibly even lower burden on the plaintiff signaled in the Wheaton College case?
Well, it's certainly going to make it easier to challenge federal laws. And for example, President Obama is planning to issue an executive order banning contractors from discrimination based on sexual orientation.
Right.
And already religious leaders have written a letter to him stating that, given Hobby Lobby, he might think about including an exemption. Mm-hmm. That. So I think that the ramifications are real, and they're not long in coming. It'll be interesting to see what is ultimately decided for that. Now, that's a little different because that involves government funding. Right. And once government is spending its own money, one would think it should be able to have a little more control over where that money goes to. Right? So I think there's definitely an argument to be made that, listen, if you're spending taxpayer dollars, you should not be directing it to people who are going to discriminate on grounds that we have agreed should not be the basis for discrimination.
Right. Do you think that this is not what Congress intended with RFRA with regard to how the Hobby Lobby series of cases have come out so far?
I absolutely do not think that this is what Congress contemplated at all when they passed RFRA. RFRA was widely supported by groups from very conservative to very liberal, and I don't imagine you would have had a consensus for expanding RFRA to for-profit corporations. And there was certainly absolutely nothing in the legislative history to support the idea that they wanted RFRA to apply to for-profit corporation, nor was there anything in it to suggest they wanted to expand it to such an extent that any burden on religion would trigger heightened, strict scrutiny of the law. Right? It said substantial burden.
Right.
That language was borrowed from the free exercise. And again, the point of RFRA was to sort of track free exercise jurisprudence before Employment Division versus Smith.
Right.
Not make a radical break with it.
Do you think that Smith was the right result in that case?
So Smith is a really hard. That's a good question, and there are different issues to consider. If Smith hadn't been decided and we had ended up with a regime like the one we have now. So, for example, if free exercise were understood to grant an exemption anytime a plaintiff said there was a burden and the law didn't pass strict scrutiny, I think that would be a very problematic legal regime.
Mm-hmm.
And there is also a question of granting exemptions for people with deeply held religious beliefs, but not granting exemptions for people with deeply held moral beliefs. And so there's a whole question of, well, should religious beliefs be treated so distinctively? On the other hand, right, there's always the issue of, what about if a neutral law does impose a substantial burden and granting an exemption doesn't necessarily burden other people?
Right.
At this point, the constitutional law does nothing for that person. Under
Smith,
the constitutional regime does nothing for the person whose religious beliefs are substantially burdened and for whom an exemption would not impose on anybody else. I think that is not that should give people pause. On the other hand, the regime we have now seems to grant religious exemptions for absolutely any claimed burden, which is also problematic.
Right. So we have this statutory regime which gives more leeway to religious objectors than the Constitution does at this point.
At this point. So the Constitution arguably doesn't provide enough, although maybe that's just as well because we don't grant any accommodations for people with deeply held moral views. On the other hand, the statutory rule, that's the Religious Freedom Restoration Act, seems to be a little too free with its exemptions. Because let's not forget that granting a religious exemption in these cases imposes substantial burdens on third parties.
Right.
And when that happens, right, then that's, again, something that should give people pause. And so, again, coming back to this idea that there's really the court seems to be reading out any objective requirements for substantial burden. It's going to cause a lot of harm for third parties.
Right. All right. Well, I guess everybody needs to stay tuned.
I know. I don't know if we'll have to meet again in 3 days.
Right. Some other case will reach the court on an emergency appeal. And yes. Okay. Well, thank you again for helping us parse all of this out.
My pleasure.
Okay. Bye-bye.
Bye.